Wow, that's weird. Okay. All right, let's get started. My name is Matthew Perry. Not that one, but that one. A little bit about myself. I'm a board member of the Appalachian Institute of Digital Evidence out of Huntington, West Virginia. I'm a board member of 304 Geeks. Interesting thing about that is that I'm the treasurer of the 304 Geeks, and all the other members of 304 Geeks are better computer guys, better hackers than me, but somehow I'm the guy who controls the money. I'm not exactly sure what that means, but who's the hacker really? I'm one of the founding members of HackerCon, which is coming up, and we'll talk about that in a minute. I currently work at the Masters Law Firm. I'm a board member and run an online gaming group called Red Sky. And in my spare time, I have a wife, 3 kids, and a grandbaby, and I'm a licensed minister. One of the things I learned in seminary, which I hope will come through today, is the key to a good sermon is to have a good introduction and a good closing and not make them too far apart. So what do I really do? Well, I do litigation support, I do trial support, I'm a network administrator, I do database analysis, and I carry boxes. And that makes me the computer guy at a law firm. Yay, HackerCon! Throughout the rest of the talk, anytime the HackerCon logo comes up, whoever says yay HackerCon gets a free shirt. HackerCon is in Charleston, West Virginia, October 19th through 21st. We've got a bunch of good speakers. We've got a bunch of good free workshops. Tickets are $75. If you want to know about it, go to the website. Now, what this talk is about, it's about current trends in computer law, and I had a lawyer at the office review this, and so here's the disclaimer. Nothing that I'm about to tell you should be construed as legal advice or the opinions and views of anywhere that I work, have worked, will work, or will ever work in the future. These are my own thoughts and legal and commentary on certain legal issues. If you have your own legal issue, please consult a lawyer for yourself, not me. So the 5 topics we're going to talk about today are civil law, virtual property law, intellectual property law, fair use law, and criminal law. And what I'm basically going to do in this presentation is go over questions that I'm commonly asked and try to answer. So the first question is, well, what really is civil law? Civil law is a body of rules that delineate private rights and remedies and govern disputes between individuals in such areas as contracts, property, and is distinct and separate from criminal or public law. So what's the first question? Can you get sued if you screw something up? The answer is yes. How do you mitigate that potential? Number 1, you make sure that you have a good contract. Number 2, get yourself some errors and omissions insurance. It's not expensive. It'll take longer for you to explain to your insurance guy what errors and omission service insurance is and why you want it than it will for you to get it. And then make sure that you know who you're working for and what you're doing. Back when I used to work for these guys, we had a case where this guy left a construction company. Well, his old company started losing all their bids, and they suspected that this fella had stolen some stuff from him. He started his own construction company. And so they called us, we investigated it, and sure enough found out that what he had done was he had purchased a computer system exactly like the computer system that was at his old company, and he hired this computer guy to load on a backup tape that he had stolen. Now, he loads on the backup tape, doesn't think anything about it. They tell this guy that, you know, they'd had some kind of system event and he needed to wipe the system and load this, so he does. Well, what that had on it was the old construction company's bid system. So this guy, the new company, was now able to underbid the old company on all of their contracts. Well, so we roll in, charge everybody, including the computer guy. He ended up getting free and clear, but had he just done a little bit of research before he took that gig, he would have known this was a new company and there was no way that they had a backup tape with this amount of data on it reaching back years. Is there money to be made in the civil law field? And the answer is yes. You can be an expert witness. Anybody in this room could be an expert witness. The definition of an expert witness in court is that you know more about a technical topic than the jury does. And I guarantee you, every person in this room will know more about any computer topic than the 12 people sitting in that box.
Is Gregory Evans in here? Okay. You're right. You're right.
Number 2, e-discovery. We'll talk about that for a minute. And number 3, digital forensics. Expert witness. When a company sues another company, or when a person sues a company, they want data. They want the stuff that's about what they're suing about. So, and it could be anything. In this particular example, this is gas company records. And so when the defendant turns over the data, it's always in a common and limited ASCII file. Well, that means nothing to a lawyer. Nothing. The job opportunity for the people in this room is if you could take that common to limited ASCII file and turn it into that, and then run some queries on it and turn it into that, which is an exhibit that a lawyer can use at court and be able to explain to the jury. It seems simple to the guys who do penetration testing and do a lot of stuff, but I made my house payment doing that 2 years ago, or my house down payment doing that 2 years ago. E-discovery. This is the newest area in federal law, and it's moving its way down to state law. And what that basically means is that when you sue a company, they have to turn over all their documents in electronic form. And in the old days, when we would sue a company, we would get that. That's the actual production of documents in the Purdue Pharma OxyContin case in our office. And that's the paralegal who was in charge of maintaining that, sitting on top of it. Nowadays, you don't get that. You get the equivalent on disk. So what does that mean for the law firm? Well, that means that they have to have somebody that can OCR that. They have to have somebody that can write searches and queries to maintain that. And that's a big opportunity for business. Digital forensics. Now, that picture's obviously photoshopped, and this is just one small part of digital forensics, but we had a case where it was a car accident case, and the defense turned over to us pictures of the inside of the wrecked vehicle with beer cans on the floor. Now, we thought that was odd because the police report mentioned nothing about alcohol. Our client said absolutely there was no alcohol in the car, he wasn't drunk. But there they were, beer cans in the car. So we send the picture off to get it analyzed. Sure enough, somebody photoshopped in those beer cans. Any questions about civil law? All right. Virtual property. Do you own your virtual property? This area of the law is hotly contested and changing quickly. Is it your property, and can the company deny you access to your account? And what is fair use of your virtual property? Let's look at a case. This is the case of Bragg versus Ladin Research. Ladin Research is the company that owns Second Life. Mr. Bragg was basically running a real estate scam in Second Life, and he was doing very well. Second Life decided that he was violating the EULA, and they blocked his account. Now, at the time they blocked his account, he had $70,000 in real money on the line on real estate deals. So he sued. The case eventually was settled out of court, but there were two very important federal district court rulings that came out of this case. Number one, the district court decided that Second Life's terms of service of mandatory arbitration provision was unenforceable. Now, what does that really mean? It means Mr. Bragg and his attorneys broke the EULA. This is the only case I know of where somebody broke the EULA. The EULA said that if you're going to have a dispute with Leiden Research, that California law governed it, and you had to drive to Palo Alto, California, and have a binding arbitration. Mr. Bragg's lawyers were able to break that, and he was able to sue them. If you see that this case is in the Eastern District of Pennsylvania, he was able to sue them in his home court. And the reason he was able to sue them is the second important finding. The court decided that interaction with a person in a virtual world can satisfy the state's minimum contacts requirement for personal jurisdiction. Now, what does that mean? That means that he was sitting in his basement in his pajamas, playing on Second Life, running his real estate scam, but he had contact in his computer in his basement with people from the company. And the court ruled that that gave that local court venue and jurisdiction, and he didn't have to go to California to sue. He didn't have to go for arbitration. Very important case. Blizzard versus Peons for Hire. Peons for Hire was a World of Warcraft gold farming company. Blizzard sued them and said that you can't do that, but they didn't say that you couldn't farm gold. What they said was that you can't use the World of Warcraft internal communication system to advertise your services, and they put Peons for Hire out of business. The next one we'll talk about is your and my favorite agency, the RIAA. Boo is right. They say that you don't own your iTunes after you buy them. There's a company out called Redigi, and what Redigi is basically a used record store for electronic music. If you downloaded from iTunes, decided you didn't want it anymore, you could sell it to Redigi, and they would in turn turn around and sell it. And they were following the rules and were only selling it to one person. They weren't selling it to 1 million people. Of course, the IRA said, no, you can't do that because no money goes back upstream to Apple and the record industry. This case is currently in legislation. It's in litigation, and probably be tried this year or next if they don't work out a settlement. Here's another interesting case. Our buddy Bruce Willis was having his lawyers do his will, and he decided in his will that he wanted to leave his apparently vast iTunes collection to his 3 kids. Well, he had his lawyers research it, and as you can see at the bottom, what the newspaper reported about this case, but under iTunes' current terms and conditions, customers essentially only borrow tracks rather than owning them outright. So any music library amassed like that would be worthless when the owner dies. So he sued to get the right to pass these iTunes on to his kids, and as you can see, this case was just back in the spring, and so it's still in court. Question? Any questions about virtual property law? All right. Intellectual property law, copyrights, patents, and trademarks. A copyright protects expressive arts that give the owners exclusive rights to reproduce their work, publicly display or perform their work, and create derivative works. Additionally, owners are given economic rights to financially benefit from their work and to prohibit others from doing so without their permission. It is important to realize that copyrights do not protect ideas, only how they are expressed. There's a good website that contains a lot of good information about intellectual property and intellectual property rights. A copyright provides protection for original works of authorship. This next part is very important. Copyright protection attaches as soon as the work is fixed to a tangible medium. It is not necessary to file for copyright protection. There may, however, be certain advantages to registering for a copyright. For works of U.S. origin, registration is required before an infringement suit may be filed. If there is a timely registration of work, the owner of the copyright may receive statutory damages for infringement beyond any award of actual damages and profits. If you're going to write something and you think you might want to sue in the future if anybody else uses it, you have to get a copyright. Otherwise, no copyright, no suiting. Do you own your code? This is a question I get asked a lot. Well, if you work for a company and you wrote something, the answer is probably no. Look at your employment contract. It will govern whether you own your code or not. If you don't have a contract, the answer is no. Why? Well, you probably used company time, company resources, company ideas to write your code. Now, of course, if you work for yourself, the question is moot. But if you work for a company, you probably better check. Now, back when I worked for these guys, I wrote a program to do this. Now, not play Call of Cthulhu, but if you see down at the bottom, there's a little sticker on that license plate. At the department, we sold those stickers, and they were hard to keep track of. People were stealing them all the time. And so I wrote an inventory control point of sale program to manage and maintain and sell those stickers. Well, when I left, some people at the county advised me that either A, I should take my program with me because we didn't exactly part as friends, or B, I should charge them for my program. Well, after we got into a little bit of a legal battle, it became very clear to me that, number one, I didn't own that program. Number two, they were keeping it. And number three, they didn't want me maintaining it after I left, so they promptly took it since they owned it and threw it away. Patents. Patents protect an invention from being made, sold, or used by others for a certain period of time. There are three types of patents in the United States. Utility patents, which cover inventions, design patents, which cover unique designs and processes, and plant patents, which oddly enough cover plants. I'm not really going to talk about patents, that's not my thing, but I will say that the patent system in this country is broke, and there'll probably be some legislation in the near future, we hope, to straighten all that out. Sure, go ahead.
So, even if we were forward in the United States, how does that affect if somebody takes intellectual property
To another country? Well, you're going to have a hard time. You're going to have a really hard time suing somebody offshore. Your best bet is to make sure that it's protected before they leave with it. We've sued companies out of the United States before. If you can sue them here, like if you've invented something and then they turn around and selling it here, you stand a lot better chance. If they just take it over there and they're not ever coming back here, your chances are slim. I can tell you, my experience.
I mean, there's been a recent attack against AutoCAD, where as soon as if it's on the machine, as soon as they save an AutoCAD drawing, you ship the copy out offshore.
Right.
So you've never had a chance to even patent it or protect it or anything.
Well, now since it's an AutoCAD drawing, I mean, you go back to the slide about copyrights. As soon as that idea is saved to a tangible form of media, which would be the hard disk, then it's copyright protected. Now, if you filed and said, this is the date I saved it, and this is the date that then after that it got shipped out, you would be protected. Okay? So trademark is that. This is HackerCon's trademark, which is October 19th to 21st, Charleston, West Virginia. Any questions about intellectual property? Sorry, that was a bad throw. All right. Next, civil law, fair use. I found something really cool on the internet, and I want to use it. Fair use is a limitation, exception to the exclusive right granted by copyrights and to the author of the created work. In the United States copyright law, fair use is a doctrine that permits limited use of copyrighted material without acquiring permission from the rights holders. Examples of fair use include commentary, search engines, criticism, news reporting, research, teaching, library archive, scholarship. It provides for the legal, unlicensed citation of or incorporation of the copyrighted material in another author's work under a four-factor balancing test. Now, what is that four-factor balancing test? You might ask. Number one, What is the purpose and character of the work that you're copying? What was it made for, and what is it? What's the well, the next one is what is it? Nature of the copied work. What is it? Is it a song? Is it a picture? Is it a book? The amount and substantiality, are you copying the whole thing or just a little piece? And the effect on the work's value. You know, is what you're doing going to enhance the value of the original work? Is it going to detract from it? Or is it going to do nothing? Let's talk about this fella for a minute. This guy's from my hometown. He's a captain in the Delta Force, and he was sent off to a faraway country to meet new people and shoot them. He was, in 2005, a Life magazine reporter was embedded with his unit, took this picture, a bunch of other pictures of him, and his story appeared in Life magazine. Nice story, great guy. So at the end of his rotation, he comes back to the United States. He's with his kid in Walmart, and guess what he sees? Of course, his kid goes, "Daddy, why is your picture on a book that says Killer Elite?" He didn't know how to answer that. He's upset by this, obviously shocked. So what does he do? He calls us. Well, we get to investigating it. Turns out there's a book, there's an action figure, there's T-shirts, and there's a whole franchise with this guy's image on it, floating around all over the world. So what do? Well, you know, like the good law firm we are, we sue everybody. We sue the author, we sue the book company, we sue the publishing company, we sue the toy manufacturer, we sue the T-shirt company, we sue Cafe Press, and at the end of the day, they all settle, they quit selling this stuff, they quit making the T-shirts, they change the cover on the book and put out a second edition, and everything's all right, right? So he goes back to Afghanistan, or out to the sandbox again, meets more new people, and shoots them. 2010, he comes back home. Guess what happens? So that comes out, and he comes into our office, and he says, you know, look at this. So we sue EA, and of course they say, it's not him. That's not his picture there. You know, that guy on the cover of the game is not the same as the guy in the middle picture or the other guy. It's not him. Well, they settle. And of course, they didn't change the cover of the game, but they settle. And he goes back to work, and he's now in Africa. Question? Any questions about fair use? Yes.
This might be just a bigger discussion, and I don't want to spend a lot of time on it, but if the DMCA prevents fair use, who wins in that battle?
What was the last part of that? I'm sorry.
If the DMCA prevents you from exercising your right to fair use, who wins?
Well, it's going to depend on each individual case, of course. You know, if I mean, you're right. That's a bigger question. Ask me that after.
There have been exemptions granted, like
Right.
for jailbreaking phones. There's a specific DMCA exemption granted that, but my understanding based on the fact that exemptions have to be granted is that if you violate the DMCA, even if what you're doing is fair use, you violate the DMCA, there is an exemption granted. So that's just my understanding based on what I've heard.
Well, I think that's right. And there's a question that, there's a case that I'm going to bring up later in the criminal part about the Sony case where the guy jailbroke the PS3 and what he was charged with.
Well, the
Yeah.
case of Apple, they just didn't pursue the guy. So is that granting a position, or is they just letting it go?
Well, you know, I think that was a financial decision. Next subject, criminal law. Number one, what is criminal law? Criminal law governs crimes, including felonies and misdemeanors. Crimes are generally referred to as offenses against the state. I met a guy this week named Glitch, and I don't think he's here. Let's see, but he asked me a question while we were at breakfast the other day that I didn't really know the answer to at the time, but I'll go ahead and pose the question now and tell the answer. His question was, if I'm scanning a bunch of stuff and I scan a router or computer at somebody's house, potentially by accident, I assume, can I be charged with something? And at the time, I didn't really know the answer, but I did a little research since then, and there was a case, it's not exactly the same, but it's sort of similar, in Florida, where these people were in this cul-de-sac. They look out their window and they see this van parked outside. And after a couple of days or a day or so of this, they call the cops, and turns out there was just this guy in this van hijacking everybody's wireless and using it to run some stuff. Well, they didn't know what to charge that guy with necessarily, but what they ended up charging him with under Florida law was trespassing. Even though these people had unsecured wireless routers, they ruled under Florida law that he was still trespassing into their property and house and using their stuff to use the internet. So I don't know if you're scanning and you just like hit it and you're not doing anything, that's going to be a local law question. I couldn't find any cases exactly on that, but I thought it was an interesting question. Well, no, it wouldn't be illegal to walk up and knock on the door, but it would be illegal to walk in and get a beer out of the fridge. Maybe. But see, that's a local law issue. You know, every jurisdiction, that's going to be different.
I think in Florida, they're allowed to shoot you anyway, though, if you're wearing a hoodie.
Yeah, that's a good point. In Texas, they can shoot you when you get out of the car. All right, question number 1 for criminal law. Will I get arrested for having one pic like this on my computer? Oh my God, that's disgusting. And the answer to that is, could you? Yes. Will you? Well, not very likely, unless, and it's a big unless. Last year at the Appalachian Institute for Digital Evidence meeting in West Virginia, the head of the West Virginia Prosecuting Attorneys Institute was asked that question, and this is his answer. He said that he had never prosecuted a case with less than 50 images. However, this is a however, if the feds are after you and they're stacking charges and you have one image, they'll stack it on. Now, the other however to that though is, there have been cases in West Virginia, and I assume in other jurisdictions, where children have been charged with child pornography for sexting each other. If my 13-year-old son and his little 13-year-old girlfriend decide that they want to trade nudie pictures, child pornography, and there's a prosecuting attorney in West Virginia that is prosecuting those cases for one pic. Stacking charges. Let's talk about that for a minute. According to the U.S. Department of Justice, 94.1% of federal prosecutors' cases in 2009 ended in a conviction. Now, why was that? Well, there's a couple of reasons. Number 1, they're actually pretty good at what they do. Number 2 is they stack so much stuff on you that you are compelled to plead to something, because if you go to court, no matter how good your lawyers is, how much you spend, if you lose, you could potentially spend hundreds of years in jail.
I think it's worth pointing out that the federal code is so voluminous that just by being a normal person, you can probably violate federal law.
You'll see that here in a minute when we start talking about the CFAA. Now, back when I worked for these fellas, we had a case where this dad goes into his son's room and he finds a driver's license on the floor. Now, that may not be necessarily abnormal, except for the fact that his son was 16 and the driver's license had a picture of his son on there that said he was 22. So the guy looks around his son's room and he sees his computer and he sees this fancy printer, and he decides that, you know, he'll do the right thing as a parent. He'll bundle all this stuff up, he'll bring it to me, and I'll give his son a good talking to. Well, so he bundles his computer up, he brings it to me, I'll look at it. Sure enough, this kid was printing fake driver's license, not only for himself, but for a whole bunch of people, and selling them. But the worst part was, he was also printing, he had stolen a check from a company, and he was printing fake checks and cashing them. And of course, when we got him in the office and questioned him, they were doing what you would think they were doing. They were going to the strip club with the money. But guess what happened? he got charged with a bunch of stuff all over just that one little fake ID. Here's a good question. Can the government force you to give up your password in the course of an investigation against you? Anybody want to hazard a guess? All right. Let's look at this case. United States versus Fiscal. This case is still going on, being litigated right now. This is a case where the government came in, seized all these computers, and there was a laptop that the hard drive was completely encrypted. They tried to crack it, couldn't crack it. So they told the lady whose laptop it was to give up the password, and she said, no. My lawyer says under the Fifth Amendment, I do not have to testify against myself and incriminate myself. So no, you can't have the password. So the judge ordered, this is in Colorado, the federal judge ordered that under the All Writs Act, she had to provide an unencrypted password. She still said no, so he threw her in jail for contempt of court. Now, her lawyers appealed the judge's decision. Now, this is the important part that if you don't take anything else away from this, you need to remember. The 10th Circuit Court refused to intervene in the matter since the case had not yet been resolved in lower court. Now, let me explain what that means. If you've never been involved in the court system, this takes a little bit of explaining. The way the court system works is there's the district court, there's the circuit court, and then there's the Supreme Court. The way appeals work is after the case is decided in district court, you can appeal the decision to the circuit court and then ultimately onto the Supreme Court. There are only a couple of very limited exceptions in which you can appeal before the decision. So, since the circuit court refused to hear the appeal, she has to either A, sit in jail forever for contempt of court, or B, give up the password, and then if she's convicted, appeal the guilty verdict to the district court and say, hey, I shouldn't have had to give up the password. I was convicted wrongfully. Can you overturn the verdict? And they will either say one of three things. They will say, yes, you're right, the verdict's overturned. Yes, you're right, but you would have been convicted anyway, you're still guilty. Or no, you're wrong, you're guilty. Next case, United States versus Scarfo. This guy, the federal agents busted into his business in the dark of night, tried to download his hard drive, couldn't because it was encrypted. So they go back to the judge and they get a warrant to put a keylogger on his system, break back into his office, put the keylogger on, wait a couple of days, break back into his office, get the encryption code, download the stuff. And the court approved all those search warrants. Now, why did the court approve this stuff and why did they do that? Because in both these cases, the government knew, and when I say knew, I mean knows, of the existence of the files that they were looking for on your computer. And if they know that, you will most likely be compelled to give up the password. And how they knew in both these cases is in the first case, they had a wiretap conversation where this lady was talking to somebody else about what was on her laptop. Number one. Number two, in the other case, a former employee ratted this guy out. So that's how they were able to get the warrants. That's how they were able to do what they did. Now, the other big thing that's going on about passwords right now is Facebook stuff. You wouldn't think about it, but Facebook has become a really big part of court cases and evidence just in the last few years. In civil cases, if some guy gets hurt at work, he files a comp claim, and in the next week he posts his ski trip on his Facebook page, one of his friends rats him out, then what happens? Well, they file to violate his workers' comp, and then the judge orders him to give up his password for his Facebook. Same thing with divorce cases. One of the first things a good divorce lawyer does is go after the other person's Facebook account to see who they've been fooling around with. And then in criminal cases, sometimes the judge will order the Facebook password disclosed so they can see if they knew the person, maybe if they killed somebody, if they knew the person, if they were around them or where they were at the time. of the incident. Interestingly enough, there was a case in Tennessee where the judge ordered the defendant to friend him so that he could review the evidence before he disclosed it to the other side. Here's another question. I'm a hacker. Does that mean I'm a terrorist? Outside of the United States? Yeah, probably. For this talk, I looked at a bunch of cases outside the U.S., and yeah, they pretty much charge you with terrorism everywhere else. In the U.S., maybe, but you are more likely to be charged under the Computer Fraud and Abuse Act. Here are the three things you have to have done to be charged as a terrorist. Number one, retaliate against someone or something. Number two, gain access to classified information. Number three, cause damage to a governmental computer. Here's a little bit about the Computer Fraud and Abuse Act. This act governs cases with a compelling federal interest where computers of the federal government or certain financial institutions are involved, where the crime itself is interstate in nature, or where computers used in interstate or foreign commerce. This act was passed in 1986 and has been amended 6 times. Subsection B of the act punishes anyone who not only commits or attempts to commit an offense under the act, but also those who conspire to do so. If I hire Rob to hack into something, I'm as guilty, potentially, I can be charged the same as him. And if he fails, we can still both be charged.
Question.
Yes?
If me and a bunch of people discuss a way to get into something and one of us doesn't, are we all liable?
It's a good question. Potentially under Conspiracy Act. It will go to the intent. I mean, one of the things I thought about in this talk is, are we all guilty of conspiracy for coming to DerbyCon?
Right.
And the answer is no, because of the intent. I mean, the intent of this, nobody here is here going to class, or nobody here teaching is teaching anybody with an intent to perform a specific act. Now, if you and your buddies are all sitting around in the coffee shop and you decide, yes, we're going to break into this and we're going to do this and this is how we're going to do it and you should do it, then yes, you could be charged. I'll skip over this part pretty quick because I'm short on time, but you guys can look up the CFAA code. Basically, what you were saying was exactly correct. The definition in this code are broad enough that any computer anywhere can be included. Here are the 6 things under the Computer Fraud and Abuse Act, and I won't read them all. You guys can look them up and read them, but they're pretty straightforward. If you just wiki CFAA, you'll see these on there. Here's a few cases we'll talk about real quick. Number one, this first case is one I really want to get to because it's really important. This fellow, Mr. Kramer, was charged with hacking, and it was basically a social engineer hack. This is the first case I saw with a guy charged with social engineering hack, because what he did was he used his cell phone to talk, text, or picture some young girl into having sex with him. Well, they charged him with hacking, as well as the sex crimes. Of course, everybody knows about the Bradley Manning case. That's the WikiLeaks guy. He was charged under the CFAA. Here's the United States versus Drake case. This was a whistleblower case where this guy wanted to expose the Trailblazer Act of the NSA, and he got charged under the CFAA and pled down to that. The next one is the Sony case, where this guy got charged for jailbreaking his PlayStation 3. But if you notice in this one, there's 2 cases, and they flipped. So he countersued and said that that they didn't have jurisdiction to sue him over that, and this eventually settled and he prevailed. This next one is on here just because it's so ridiculously funny. And a few years ago, everybody remembers in the news, school district in eastern Pennsylvania decides to give everybody in the high school laptops, and to ensure that nobody that's using it wasn't supposed to be, when you turn the laptop on, it took a screenshot with the webcam of who was using it and mailed it back to the school board. So consequently, you ended up with 66,000 photos of 15 to 16-year-old girls in their bedroom with various states of undress. The next one, these are 2 cases that are really common to be charged with under this act. This is just like the case I was talking about earlier. This guy, the LVRC case, this guy leaves his business and he takes some stuff with him he shouldn't have to start his own competing business. In the International Airport case, this guy leaves his company and he deletes a bunch of stuff to hide his alleged bad behavior. Now, who's never done that? I've never done that. Now, you may say, Matt, what I did was a long time ago. It shouldn't matter anymore. Well, here's the long time ago. Civil actions have a 2-year statute of limitations requiring the civil action to be brought within 2 years of the date of the act complained of or the date of discovery of the damage. I did something a long time ago, but they never found out about it. Guess what? When they find out about it, the 2 years starts then. In the absence of a specific statute of limitations, the default federal limitation is 5 years. There are 2 exceptions to that. Number 1, act of terrorism is 8 years. Or number 2, if it could have hurt somebody, either it did or reasonably foreseeably, then there is no statute of limitations. This is my last point. What if you're sitting in your bedroom, in your mom's basement, in your pajamas, hacking along, and you run into this guy? He comes and kicks in your door and says, I am the law. You're in trouble. Well, what should you do? Number 1, you should do that. Everybody remember these words of wisdom from Ron White in his comedy routine. I knew I had the right to remain silent, but I did not have the ability. Do not be that guy. Now, when I had the attorney in my office review this talk, this is the point that he added. So I put it in at 1.5. Don't do anything. And what he meant by that was, don't rush to your house after you get done not talking to this guy. Tear your hard drive out of your computer, smash it in 1,000 bits and throw it away. Because what will happen is eventually, if you get charged and the court orders you to produce said hard drive and you can't, then it's called, this little thing in the legal world called expoliation of evidence. And if you can't produce it and they say you have to, then it can be assumed an admission. So if they say, we think you had 5,000 kiddie porn images on your hard drive, but now since you can't produce it to prove that you don't, guess what? You did. Number 2, call a lawyer. Number 3, and this is the most important thing, do exactly what the lawyer says. And the first thing the lawyer is going to tell you is, number 1, is there money to be made in the criminal law field? Well, yes, there is. You can be an expert witness, same as we talked about before. You can do digital forensics. There's a nice little school just down the interstate in Marshall, in Huntington, West Virginia. They were the first digital forensics program to be accredited in the nation. There's their site. That's where AID is run out of, and there's their website. And that's it. Any more questions? Any more questions? All right. Thanks, guys. Get up, walk around before you freeze to death.